versus Robert Dobroszewski.
Assistant prosecuting attorney.
Mr. Jerkus, you got to move. They're coming through. Thank you.
Assistant prosecuting attorney Morgan Barroso on behalf of the
Alex Warren Green on behalf of Mr. Drobashewski.
Robert Edward Droboszewski, Your Honor.
Dobroszewski. Okay. What are we doing?
Your Honor, I'm asking the court to set a competency hearing in this matter. I've prepared an order for the court's signature.
Forensic evaluation will be ordered. I'll set a competency hearing for, well, actually 6 p.m. March 28th, 2024, 9 a.m.
Right away, this hearing starts with tension before the defendant even fully speaks. The court is preparing for a competency evaluation, and that changes everything about the direction of the case. A competency hearing is not about guilt or innocence. It's about whether the defendant is mentally capable of understanding the legal process and assisting in his own defense. And the second that issue enters the courtroom, the judge has to slow everything down, even if the defendant wants to move fast. What makes this moment so dramatic is that you can already feel the collision coming between procedure and emotion. The defendant wants immediate control, immediate resolution, immediate action. But the court system does not move emotionally, it moves structurally. Judge Simpson is calm, measured, and very careful with his wording, because once competency becomes a question, every future legal decision becomes sensitive territory. And trust me, that frustration building in the defendant right now is about to completely reshape the atmosphere of this hearing.
Excuse me, Your Honor. Good morning, sir. May I please address the court?
I don't know, Mr.
Respectfully.
What would you like to tell me, sir? Yes, go ahead.
Your Honor, I come here to plead guilty to all charges.
Well, Mr. Drobashewski,
Listen, sir, why not?
because I just,
Yeah, but you're not even my attorney. You're not my attorney. We talked about that yesterday.
Mr. Dobroszewski?
Yes, sir, Your Honor.
All right.
then that's gonna happen today.
Until the evaluation is complete, I hear you, but
Yes, sir.
until the evaluation is complete, I'm not going to accept your plea. You need to talk that over with your attorneys.
I don't have an attorney, Your Honor. I'm going to be representing myself. I'm not going to have the state represent me.
Well, then that becomes a whole other issue because
Okay.
right now they're assigned to the case.
Okay. Well, I can tell
Right.
you right now, Your Honor, you're going to send me to the hospital and I'm not going to
Hey,
talk to them and say a word to
Robert,
them.
I think,
Okay. And I'm making the decision. I'm not going to accept your
Yes, sir, Your
guilty
Honor.
pleas to these charges.
Okay, Your Honor.
Okay.
Yes, sir.
And so I'm going to set the hearing. We'll see you March 28th.
Yes, sir.
You can talk to them or not talk to them. I'd suggest that you do.
Yes, sir.
It'll move the process along, but that's going to be up to you.
Yes, sir.
Okay.
Yes, sir.
At this point, then I'll continue your bond. All
Yes, sir.
right. Thank you.
Thanks. Have a
Sir.
nice day, sir.
You do the same. Let's call the case. People versus Syed Lewis.
assistant prosecuting attorney Morgan Barroso on behalf of the people.
I'm Lauren Brown, Deputy Public Defender, and on behalf of Mr. Lewis. Mr. Lewis, please state your name for the record. Your Honor, today is the date and time set for a probable cause conference. We are respectfully requesting that this matter be set for a preliminary examination.
Now we transition into a completely different type of courtroom conflict, and this one revolves around bond violations and exclusion zones. The defense is trying to frame the situation as accidental, not intentional. That distinction matters a lot in court. An intentional violation makes a defendant look dangerous or reckless. An accidental violation gives the defense room to argue for leniency. Notice how carefully the attorney keeps repeating ideas like, he wasn't driving, he didn't know, and there was no contact. That's not random wording. That's strategic damage control. They're trying to convince Judge Simpson that this was a technical mistake instead of a deliberate breach of court conditions. But prosecutors love patterns, and once multiple incidents start appearing on the record, judges begin looking at behavior differently. And here's the bigger question for everyone watching this case. If someone already knows there's an exclusion zone in place, How much responsibility do they carry to avoid even getting close to violating it? That gray area is exactly where courtroom battles become dangerous for defendants.
We'd like to address the bond appropriate time for the bond violation.
The violation.
Yes.
Discovery complete.
Yes, Your Honor.
People have their witnesses available to sex.
Yes, Your Honor.
Preliminary examination in this matter will be set in person February 6, 2024, 9 a.m. That is before Judge Perry.
Thank you, Your Honor.
As to bond.
Your Honor, there's a bond violation. It notes that my client went past a zone where the complaining witness lives. It alleges that he did that twice, I think maybe 3 or 4 days apart. My client was in a vehicle.
In between being warned.
Well,
Correct. Okay, go ahead.
so he's in a vehicle. He's not driving on either occasion. At the first time, he was not aware that that was the zone that he was supposed to be kept out of. Second time, they had sent a notice to his recorder or recording device. He didn't get that notice in time. The second time, he was still in the vehicle and still drove past the zone. I should note that to the best of my knowledge, there was no contact, no sighting by my client of the complaining witness or vice versa. No contact, nothing of that sort. Something that was inadvertent and unintentional. Even the second time, he was too slow to get his messages to be told that he had gone past the zone. So this was a violation that certainly was not intended by my client. We're asking that his bond be reinstated. He now understands where the zone is. He knows to stay out of that zone. And again, there has been no allegations of any contact of any sort between myself and the complaining witness in this matter.
I just want to make sure I'm looking at this correctly. This was
This is where the hearing suddenly gets more serious. Up until now, the defense had a decent argument centered around misunderstanding and lack of intent. But the prosecution just introduced something far more damaging: alleged phone calls to the victim. And notice the timing here. Prosecutors aren't merely arguing about geography anymore. They're now hinting at possible violations tied to direct communication and no contact restrictions. That changes the emotional temperature of the courtroom immediately. You can actually hear the defense trying to contain the damage by narrowing the focus back to the 4 corners of the bond violation. In plain English, they're basically saying, "Judge, stick to the evidence currently before you, not allegations that haven't been formally argued yet." Smart move legally. But emotionally, the prosecution already planted doubt in the room. And once a judge starts hearing words like repeated contact, victim communication, and multiple incidents, bond sympathy tends to disappear very quickly. This is the kind of courtroom moment where momentum quietly shifts without anyone raising their voice.
While you look at that, I would note that he was out on bond before and there were no indication of any bond violation before that.
response from the people.
Yes, Your Honor. We are actually in the process of writing a forfeiture by wrongdoing motion based off of jail calls that the defendant has been making to the victim since he came into custody. So at this point, we are not pleased with the 2 violations of the exclusion zone, but beyond that, we think that there are additional issues with violations of the bond and the no contact order.
So specifically, in response, specifically dealing with the 4 corners of the bond violation. Again, there's been no allegations of any contact whatsoever or any knowledge that he was in the zone at the time that he was going through the zone. He was not driving. He was in a vehicle driven by someone else at the time. So going just on what we have before us as far as the bond violation, I don't believe that was as to a forfeiture by wrongdoing. We would leave the people to their proofs on that, but I don't think that that's germane to this particular bond.
Well, when are the alleged phone calls?
The alleged phone calls, I apologize, Your Honor, going back through, they are from December. So they are prior to when he has come back into custody, from December 9th and 10th and 12th. There are 7 calls in total. right after he was arrested on this offense, Your Honor.
So does, Your Honor, does the court have dates of the alleged violations here?
The
The
violations of the
tether, the zone.
tether, yes, I have the report. It looks like the 13th.
Of January,
Pardon?
of January?
Yeah.
Okay.
And now the judge starts drilling into the timeline personally, which is never a small thing. When judges stop relying entirely on attorneys and begin questioning details themselves, it usually means they're testing credibility. The defendant's explanation about visiting the barber and unknowingly passing through the exclusion zone may sound reasonable on the surface, but Judge Simpson is clearly looking at repetition here. One accidental mistake might earn sympathy. 2 incidents start looking like a pattern. The defendant is also fighting another courtroom problem that people don't always notice perception. Even if he truly wasn't trying to contact the complaining witness, repeatedly entering restricted areas weakens trust with the court, and trust is everything during bond discussions. Once the court feels conditions are not being respected consistently, restrictions tighten fast. You can hear the judge balancing fairness with caution in real time. He's not exploding emotionally, he's calculating risk. And honestly, that calm tone from a judge can sometimes be more dangerous than outright anger, because it usually means the decision is already forming internally.
And then, well, that's the date of the report, certainly, and what they say the violation occurred at that time. My concern is that there were 2. Well, let me ask this. Why was he in the area?
Can I?
Yes.
My barber stays on that side of town.
You're who?
My barber stays on that side of town. I was leaving my barber's house and my friend came and picked me up. He took that route. The first warning, I wasn't aware because I didn't have verbal contact. They must have called my phone and I didn't answer. They might have left a voicemail and I didn't see it.
But you knew where you weren't supposed to be. Right?
Yeah, I wasn't aware that like the radius would be that, I was on the main road.
So, and I understand, Mr. Brown, dealing with the bond violation itself, but then I've got this other issue coming up. And people say they're going to file a motion.
Yes, Your Honor, we have actually, Ms. Zenda is drafting it today. So it should be on your desk, hopefully by Monday.
Oh, joy.
So what we have before the court now is a bond violation. We have allegations that there may have been something further, but there's no evidence or anything of that before the court at this time.
Counsel, approach briefly. All right, on this matter, record should reflect we had a bench conference in this case. I'm going to deny the defendant's motion for bond reduction at this time, and that's based upon certainly I'm taking into account the allegations as raised by the people regarding phone calls, but also there are 2 instances in which this defendant is in the zone. It's not like a one-off that just kind of occurred in this case.
There it is, the ruling lands, and it lands hard. Judge Simpson officially denies the motion for bond reduction, and the reasoning tells you exactly why. The court is no longer viewing these incidents as isolated mistakes. The judge specifically mentions the repeated zone violations alongside the allegations raised by prosecutors. Even though those phone call claims were not fully litigated yet, they clearly influenced the court's confidence level. And then comes the major escalation, revoking phone privileges. That is a serious restriction because it signals the court believes communication itself could potentially create additional problems while motions are pending. This is a textbook example of how courtroom consequences build incrementally. First comes concern, then scrutiny, then restrictions. The defense tried to frame everything as inadvertent, but the prosecution successfully shifted the conversation toward risk management and compliance failure. From a retention standpoint, this hearing completely flipped direction midway through. What began as a technical bond discussion evolved into a credibility issue, and credibility battles are some of the hardest things for defendants to recover from once a judge starts leaning the other way.
At this point, also, I'm going to restrict the defendant's phone privileges pending the motion that's going to be heard before the court. So defendant's phone privileges are revoked. Thank you.
Calls case People versus Patrick Petroprin.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Petterprin. Can you state your name, please?
Patrick Clayton Petterprin.
Your Honor, Mr. Petterprin and the Public Defender's Office is kind of an impasse. He would like to withdraw his plea. We have no legal basis to do so. At this point, I think maybe new counsel needs to be appointed if he wants to do so, because we don't necessarily agree with that strategy.
Was this a felony that came down?
This is misdemeanor, I do believe.
Yeah, it was an OWI second.
And you're wishing to withdraw your plea, but defense counsel in good conscience can't file that.
They're saying that the only way that they would be able to file it would be via the ineffective assistance. And that is not exactly what I've been trying to say, but it's rather hard to do so. I don't want to waste the court's time. I guess I also don't want to waste my time. I've been in here about 6 months. So with that being said, I guess if I have a question as far as if I did file for the ineffective assistance to see where we could go from there.
This hearing feels different because now we're watching confusion, frustration, and procedural reality all collide at once. The defendant wants to withdraw his plea, but his own attorneys are basically signaling they cannot ethically support the argument he wants to make. That is an extremely uncomfortable position inside a courtroom. Public defenders cannot simply file motions because a client feels unhappy. They need legal grounds they can defend professionally. And once the phrase ineffective assistance enters the conversation, things become even more sensitive because now the defendant is indirectly criticizing the quality of representation itself. Judge Simpson is trying very hard to cut through the emotional spiral and get to one simple question: does the defendant want this legal team or not? But the defendant keeps circling into explanations instead of giving direct answers. And honestly, this is where many defendants unintentionally hurt themselves in court. The more scattered the communication becomes, the harder it is for the judge to identify a clean procedural path forward. What would you do in this situation? Trust the attorneys or try taking control yourself?
As far as my representation, would I be able to represent myself, or do I have to wait on representation from another firm that would do this pro bono?
Are you asking that? I mean, I don't know that a motion has been filed before the court for the withdrawal of the public defender. So they're still on the case, but I'm trying to figure out what the issue is.
And if Mr. Petterprin does not want to move forward with sentencing stay, I think that's the only viable next step is for the public defender's office to withdraw, because we don't agree on the strategy moving forward.
Well,
Your Honor.
no, I understand that part. I'm just trying to figure out why. Or is there a basis upon which you're seeking to withdraw your plea, sir?
Yes, if I may, I have some notes here that I wrote down. I'll keep them brief.
Please.
All right. Now, I won't even go all over. As far as my desire to withdraw the plea, I have several things written down, but as I said, I'll try to keep it brief. For one, and I'd say the main, the fact that several of the gentlemen I was engaged with an altercation. Several of the gentlemen I was engaged with in an altercation on the night in question were moved to my blocks days, if not the night prior to my arraignment and or pre-sentencing, preliminary hearings, and so forth. Has to do with why I would like to withdraw my no contest if necessary. And to explain that, I would say that, I would say that being that it can be hard to communicate or even think, while being incarcerated and different things like that are things that would make it hard for me to make the proper decision.
The defendant is now trying to explain the emotional and psychological pressure surrounding his plea decision, and you can tell he believes the environment affected his judgment. He talks about incarceration, stress, confusion, and difficulty thinking clearly while navigating the system, but Judge Simpson keeps steering the conversation back toward procedure instead of emotion. That's one of the biggest disconnects people notice in courtroom hearings. Defendants often speak from personal experience and frustration, while judges are focused on legal standards and procedural clarity. The defendant also begins arguing facts related to the original offense itself, saying he wasn't driving, didn't have keys, and did not cause any accident-related indicators. But notice how quickly the judge cuts that off? Why? Because this hearing is not actually about retrying the entire case. It's about representation, plea withdrawal, and courtroom process. The judge is narrowing the scope aggressively to prevent the hearing from spiraling into unrelated arguments. And at this point, you can feel Judge Simpson becoming increasingly firm because the court still isn't getting a direct answer to the central issue being asked.
But I did not plead guilty. And that's why I believe that the no contest plea would certainly be, I would feel, now granted, I have not passed the bar exam or anything like that, but I feel that it would be easier to withdraw a plea of no contest than a guilty or not guilty plea. That being said, there were other issues with the offense in general. As far as, like I said, it was, the offense is a driving or operating while intoxicated. And I was not in my vehicle. I did not have keys in my vehicle. I had not hit anything on the road that would indicate that I had caused a drunk driving.
Let me just stop you there.
Sure.
Because I'm not sure that these are forming any basis on whatever. Do you want to be represented by the public defender's office or not?
Well, again, I'll ask my question again. If we do
I'm not going to
take away
answer your questions. I just need to know, do you want to be represented by the public defender's office or not?
Well, in order for me to give you that answer,
Okay, then you won't give me an answer. Here's what I'm gonna do.
Here's my answer.
Counsel, no. Stop.
No,
Stop.
I'm not allowed.
Right
I'm not
now, right now, no. Attorney, your office makes a decision as to whether or not they want to withdraw. I'm gonna adjourn the sentencing out, and you folks have to decide whether we're proceeding with sentencing or not, or whether or not he's gonna file a motion to withdraw.
I asked if I could represent myself if they were taken off. You didn't answer that question for me.
They can explain that to you. Sentencing in this matter will be adjourned.
To what date?
February 14th,
What day?
2024. What time? 10 a.m. 10 a.m. Thank you. Bond
Thank you.
continue.
Thank you, John.
What a chaotic sequence of hearings from start to finish. Across these cases, Judge Simpson repeatedly had to balance defendant frustration, attorney strategy, courtroom procedure, and public safety concerns all at the same time. In the first matter, the court refused to rush a guilty plea because competency questions legally take priority. In the second, repeated exclusion zone violations and allegations involving phone calls pushed the judge toward stricter restrictions, including revoked phone privileges. And in the final case, we watched a defendant struggle to withdraw a plea while clashing with his own legal representation over strategy and procedure. The biggest takeaway here is that courtroom outcomes are not driven purely by emotion or personal belief. They're driven by structure, credibility, compliance, and timing. Judge Simpson consistently focused on process first, even while defendants attempted to redirect conversations emotionally. That's why these hearings became so tense. Everybody wanted immediate answers, but the court demanded procedural order before anything else could happen. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.